welcome to Risk Watch Plus.
Yeah, I'm Ken Agel.
And I'm TD Wilcox. And today on Risk Watch Plus, we're going to go over some of the hottest topics curated by our editors. Each week, these editors go through and search the web for the hottest topics in compliance and risk. This week, we're going to be talking about UDAAP.
Yeah, UDAAP has been huge over the years, and it's coming back in its own way. So it's going to hit both our topics as well as our compliance spotlight.
So on June 29th of this year, the OCC released its semi-annual report on the key risk that it is beginning to see rising. And not just from the safety and soundness perspective, but also from the compliance area. The OCC sees a rising compliance risk because of altered operations, employees working remotely, and several new federal and state programs designed to support consumers, such as the CARES Act, Paycheck Protection Program, and a variety of forbearance and deferred payment programs. Ken, what should we take away from this bulletin?
Yeah, anytime you're taking a look at a dramatic shift as we've had over the last few months, these various acts themselves, while they are definitely designed to benefit individuals, they will create their own compliance risk factors. So expect additional scrutiny as institutions have applied these programs. It's definitely going to be something on the forefront for the next couple of years.
So for hot topic number 2, we're seeing a nation woefully unprepared for flood. We're seeing an uptick in flood insurance related items recently. Among them, a recent report estimates that the federal government's best efforts to predict where flooding will strike underestimates the risk to nearly 6 million homes and commercial properties, primarily in the nation's interior. Also, the 5 federal regulatory agencies have proposed a new Q&A in response to recent changes of rules for loans in special flood hazard areas. A bank in Virginia has recently been assessed a civil money penalty for a pattern or practice of violations of the National Flood Insurance Act. So Ken, is flood insurance a safety and soundness issue, or does it fall under compliance?
Yeah, it's one of those unique regulations that has both aspects of safety and soundness. We're talking about the underlying security for financial institutions as it relates to their collateral protection. But then it also has consumer protection elements, so it has compliance aspects. One of the most complex regulations in the market as it relates to compliance. Institutions always have to dot those I's, cross the T's, and prepare for the worst case scenarios, because you never know when a flood's going to hit.
Or where it's going to hit.
Yeah, exactly.
So for hot topic number 3, the OCC releases the UDAAP booklet. And some of the highlights that we're seeing from it include that it reflects a risk-based supervision approach, includes examination procedures for assessing the effectiveness of a bank's compliance management systems for UDAAP. And the key point are the red flags and risk indicators that can be used to help identify acts or practices that raise UDAAP concerns. So Ken, what is the key aspect of this new booklet compliance personnel should be paying attention to?
Yeah, it's a great booklet for all institutions because it gives powerful insights into the risk factors affecting this area. And anytime you get those risk factors, they're sort of like clues that help you to understand, hey, what do I need to focus on? Well, we're telling you what you need to focus on. Key risk indicators are powerful. When the government gives you those indicators, you want to utilize them.
And that's a perfect lead into today's spotlight item, the unfair, deceptive, or abusive acts and practices as a regulatory compliance battleground. We'll get to that right after this brief message. So for today's compliance spotlight, we're talking about UDAAP, the unfair, deceptive, or abusive acts and practices. Ken, this is a little bit of a regulatory compliance battleground, as I understand.
Yeah, that's what we're calling it, because it certainly is. When you take a look at what's been happening over the last few months, we're talking about a powder keg as it relates to everything related to UDAAP, because UDAAP gets into the meat of unfairness, deceptive acts, abusive acts, and practices. Think about the economic factors, and we're going to focus on that today in the Compliance Spotlight. Now, one of the things you have to understand is when we talk about UDAAP, we might be talking about the UDAAP or the UDAAP. One has abusive, the other does not. But historically, this comes from the Federal Trade Commission Act, Section 5. But that has now been rolled under Dodd-Frank. Historically, we always thought of UDAAP as a credit card regulation, but it expanded to broader application. Under Dodd-Frank, it states it is unlawful for any provider of consumer financial products or services or a service provider to engage in any unfair, deceptive, or abusive act or practice. Now, UDAAP violations have been the grounds for heavy penalties. All you need to do is go back and look at the penalty pages associated with UDAAP, and you'll see a litany of multi-million-dollar actions and enforcement orders. And in the most extreme cases, UDAAP can be the grounds for termination under Section 8 of the FDI Act. What is unfair? This image is an old picture of Vince Lombardi. When his team suffered a defeat, he went back to the basics and held up a football. And TD, you know what he said?
What is this?
This is a football. He wanted to get to the basics, and understanding the foundational elements of any regulation, the definitional aspects, is critical to success. So here we get into those definitions. Under the term unfair, it causes or is likely to cause substantial injury to consumers, which is not reasonably avoidable by consumers themselves and is not outweighed by the countervailing benefits to consumers or competition. So in other words, these definitions, while they're there available to you, require organizations to interpret them. What is substantial injury? What does it mean? What does it mean to not reasonably avoid something? And what benefits need to be accounted for as it relates to the particular cost or practice? The other element that we have to get into is what is abusive. Now, this is found under some of the regulations for some institutions, but not for others. What is abusive? Dodd-Frank recognizes abusive under its ownership of UDAAP, and it states the following: materially interferes with the ability of a consumer to understand a term or condition of a consumer financial product or service, takes unreasonable advantage of a lack of understanding on the part of a consumer of the material risks, cost, or conditions of the product or service, the inability of the consumer to protect the interests of the consumer in selecting or using a consumer financial product or service, and last, the reasonable reliance by the consumer on a covered person to act in the interests of the consumer. So what we're really talking about are highly interpreted elements, and that makes it very challenging. What one person understands may not be what another person understands. And because of that, organizations are well served to take the time to go through the practice of making sure that their disclosures, their advertisements convey the message that they want, but also that the message is clear. Now we get into deceptive acts or practices. This has been traditional with UDAAP. Here we're talking about an unfairness standard, but it differs from that under the FTC Act. Under Dodd-Frank, agency standards for deceptions are based on case law and guidance, and under these standards or practices, it is deceptive when there is a representation or omission of information, which is likely to mislead consumers acting reasonably under the circumstances, and that information is material to consumers. In other words, it doesn't necessarily have to be something that is presented as confusion. It could be something that is left out. And when we're talking about that, you're talking about needs for reviewing documentation, advertisements, anything that promotes that is associated with something that has a negative impact or a potential negative impact. You need to make sure that you're reviewing that document, that item, for potential deception, either by omission or commission. So what are we looking at here? Now, first thing we want to talk about is marketing elements, because under UDAAP, all marketing elements can come into play. Remember the three elements we talked about, trying to make sure that it's not abusive or deceptive or unfair. Marketing has that potential on all three sides. When we're talking about marketing, we're looking at the most important elements for an organization, but not the only elements. Foremost, you have to be reviewing your own ads for UDAAP compliance. You need to make sure that you're getting a fresh look. It's not enough if I design the ad, if I am the individual who's promoting that ad, and I'm going to be putting it into play, that I do the UDAAP review. You really want fresh eyes. You want variable eyes, because remember, when it comes down to understanding and reasonableness, different people have a different take. So then you want to take a look at the fine print, making sure that separate statements and inconspicuous disclosures are not present. So we want to make sure that everything is presented near the document. Ads themselves should not mislead or misrepresent affirmatively or by omission. Last, check your website content and the navigational processes so that consumers can find the disclosures. Remember, you want to connect the different points so that they make a cohesive argument as it relates to maintaining fairness, making sure that the documents are not deceptive and, of course, are not abusive. Now, there are 4 P's of deception. TD, you take a look at these. How many times have you ever seen a big ad with promoting something amazing?
That tiny little fine print at the bottom.
And sometimes that fine print isn't even found anywhere near. Sometimes you have to go find it on several pages away from the actual page that's promoting. So the 4 P's have been utilized for a long time as it relates to UDAAP. We're talking about prominence. Is the disclosure that's necessary to understand the product, is it big enough for the consumers to notice and read? How about the presentation? Is the wording and format easy for consumers to understand? Where is it located? Placement. Is it where the consumer would logically look? And of course, proximity. Is it near the claim that it qualifies? These are critical factors when you're taking a look at every ad. The 4 Ps can be powerful elements to avoiding UDAAP problems. All right, let's talk briefly about mortgage elements. Now we're getting into an area that is critical to all of compliance, because as we all know, for most individuals, a mortgage transaction is the most significant transaction in an individual or individuals' lives. So expect additional scrutiny as it relates to any aspect of mortgage. Certainly from a UDAAP perspective, a review of all elements associated with that particular mortgage. We're not going to walk through each of these, but when you take a look at the mortgage rule, you're going to notice that there are a number of elements that are designed to get an understanding about what the consumer has to receive. And then on the other side, there are lessons that have to be learned. Making the two come together ensures that you have complied with the requirements. Remember, this is a complex process, so having individuals within your organization understand those processes and know where the red flags are can be very significant. That being the case, it makes sense for an organization to go through a risk-based approach in order to make sure that it is going through the processes of knowing where the risks are. So TD, bait and switch, the last item on the lessons learned. Ever experienced any bait and switch?
Only in dating.
Yeah, I could see that for you. On your side or on the other side?
Hey, you know, I don't judge.
Yeah. All right, let's take a look at collection elements. Anytime you have an economic upheaval, as we have experienced, you know that collection elements are going to be rising. Whether it's in bankruptcy, foreclosure, repossession, all those elements come into play, and they're all touched by UDAAP. When it comes to UDAAP and collections, institutions have to ensure that their processes for handling those rate increases are applied appropriately. The regulatory agencies want plain language disclosures and statements. You could expect a crackdown on high fee cards and promotions to underage consumers. Anytime you have a program that is targeting a specific group, expect UDAAP to be applied to that particular effort. Let's take a look at the collection lessons. Anytime you have a high risk area such as collections, expect key lessons to be learned. Of course, good records are gold for collections. So organizations that ensure that they're going through a logical process are going to have something very valuable from both a compliance perspective, but also a safety and soundness perspective. Don't sell unverified debts. That was a lesson from the mortgage crisis of 2008. We need to make sure that we are learning that lesson for the future. Fix errors when discovered. Every organization experiences errors, but the organization that fixes those errors when they are discovered is going to be ahead of those that try to bury in order to not take the appropriate action. And last, review your collection practices and policies, especially your phone and third parties. Oftentimes, it's not just your organization you have to be concerned about, but if you've assigned the debt or the collection effort to a third party, you're also responsible for that particular party as well. All right, let's take a look at the complaint elements. As you know, UDAAP has a key aspects of complaints across a variety of areas, fees, collections, and so forth. When you take a look at the top 9 areas of complaints, you're going to see some common elements. Mortgage, bank account services, credit card, credit reporting, money transfer, student loan, vehicle, debt collection, payday loan. All of these have many aspects in common. One of the key aspects is UDAAP tends to weave its way through each of the 9. When you're talking about fees or costs or other elements associated with impacting a consumer, expect UDAAP scrutiny. So that's why you need to pay attention to which are the risk factors within your organization that might come under UDAAP Impact. Now, complaint management systems are a key element to mitigating the risk as it relates to UDAAP. Going through the process of how an organization receives those complaints, whether it's by mail, email, phone, through third-party vendors, or from regulators or groups is going to be important. Tracking the responses, including timeliness and documentation through the resolution is going to be important. Of course, reviewing the complaints for issues that may require changes in products and procedures, training, etc., is an ongoing effort of every organization. And because of that, complaints serve as a goldmine for UDAAP protection. Of course, the complaint itself may lead to UDAAP issues, but at least an organization has a mechanism for that responsiveness that we talked about is so important as it relates to lessons learned. Complaint management demands efforts. Integrating the complaint management into all phases of compliance is a critical step to ensuring UDAAP compliance. Expect a review of your institution's policies and procedures as it relates to complaints, and then expect a review of training efforts. You're going to want to see a phone number address for complaint inquiries so that you have a mechanism for receiving those complaints. If complaints have been received, you can expect heavy scrutiny on the basis of that complaint as well as the organization's response. You're going to want strong management involvement in new products and services, as well as changes to existing products and services. And given the market today, we know that there are going to be changes to those products. So utilize UDAAP monitoring to ensure that the changes fit with the requirements under UDAAP. Complaint management crosses boundaries. Therefore, organizations have to coordinate between the various departments and the business lines within their organization. A complaint-oriented regulations aren't merely just technical regulations. Sometimes it takes an artistic mentality to achieve compliance. So an organization cannot simply just dot the I's and cross the T's. It needs to delve into the causal factors as it relates to complaints in order to ensure that it is managing the risks as it relates to the organization. Now, complaint management monitoring systems have to be strong, especially in those organizations that are delving into higher risk products. If you're doing payday lending or mortgage lending or any type of higher cost product, you might want to take a look at UDAAP and ensure that your complaint management system is strong. Some type of cloud-based or SaaS-based solution may be just what your organization needs. Of course, internal audit needs to play its part and think beyond the technical and into those vague elements of complaint management regs. Remember, the definition of abusive was pretty vague and very broad. Therefore, internal audit has to think outside of the normal box. Now, review your risk. Conducting an annual risk assessment or as needed based on your own risk factors should definitely make sense. Findings should be presented and evaluated to key personnel before presentation to the board, but it should go to the board because of the risk factors here. Elements of heightened risk should be managed. So when you're taking a look at those key risk indicators as recently provided by the OCC, that's going to be something you want to factor into your risk assessment. If you need a sample UDAAP risk assessment, just subscribe and request, and we'll send you out our version of it. It could be a good starting point for your organization. Website review. Of course, your website changes, so your review should not be a one and done event. It needs to be dynamic. If you're looking for a handy tool in order to conduct a website review, we've got one for you. Of course, just email and we'll send it out to you. Now, this tool talks about some of the gray areas of advertising compliance. There are a lot of surprisingly cloudy areas, and UDAAP is one of those cloudy regulations. It requires an artistic as well as a scientific approach in order to ensure compliance. Our last tool we're talking about today is the Sample Ad Matrix tool. This particular tool helps organizations to walk through their advertisements to make sure they're not only dotting the I's, crossing the T's, but when you get into UDAAP, we're talking about those gray areas. It asks the questions that you need to answer, so this tool is also available to subscribers. In the Sample Ad Matrix tool, you'll notice that it helps to document the marketing promotion advertisement. That's a critical step. But not only that, institutions recognize that advertisement plays a role across a variety of areas. We all know that advertisement is frequently something that gets swept into production. It has to have deadlines and releases, but it also has risk factors. So ensuring that the advertisement is not only part of the overall strategy of that organization, but also having a review to make sure that prior to placement, there is a review. Keep in mind that every advertisement within an organization may be subject to various laws. Of course, we have UDAAP, but it also has Fair Lending Impact, Truth in Lending, Truth in Savings. And of course, for those institutions subject to CRA, it's going to be reviewed under that examination as well. So important to take the time, document, and this tool can help you in that regard. The specific section on UDAAP as it relates to advertisement gets into the concepts that we've talked about, making sure that it is clear. Does it ensure that it's adhering to the prominence, the 4 Ps? All of these elements are important that somebody not just quickly say, yes, of course, but they actually take the time to document. So one of the key elements is walking through these questions and then saying why it does those things. That type of affirmative compliance is powerful. And it doesn't mean that you just check the box. You've actually reviewed it. Because down the road, somebody's going to be looking at that checkbox and they're going to want to see support for the decisioning. Having that support a month down the road can be beneficial. So TD, I don't know about you, but I don't even know what I had for breakfast yesterday.
Let alone why I'm checking any kind of yes or no box.
So documenting it, because down the road, you're probably not going to remember how you came to that decision. Affirmative compliance is powerful. Just to recap on UDAAP. It isn't soft and fuzzy as people think. In fact, sometimes it has a hard edge to it, but it also has an interpretive edge. We talked about the scientific as well as the artistic elements of this regulation. So compliance with this particular law is not by chance. It is by design. The UDAAP violations themselves are definitely not soft and fuzzy. They come with a wallop. They not only hit on safety and soundness, but they also hit on compliance. So organizations would be well served to go through the effort to conduct the risk assessment as well as to document their affirmative compliance with this particular law. TD, when you factor in the current economic situation we find ourselves in, I think we can all expect greater scrutiny of this law, and that's today's Compliance Spotlight.
Thank you, Ken, and thank you all for watching. This has been Risk Watch Plus.